Good morning, everyone. Apeksha, Assistant Professor, Indraprasth Law College. Today we are going to do the topic is patent law. So I'll be starting from what is patent and what are the laws regulating the patent in India. So the grant of patent in India, it is governed by the Patent Act 1970, and it has gone under it has been amended for 3 times. The major amendments has been for 3 times, as says the second point. If you see, since 1995 by the Patents Amendment Act 1999, that is the first amendment, then the second, the Patent Amendment Act 2002, and the third amendment in 2005. Now if I take you back to the time to 1970, the Patent Cooperation Treaty was signed in 1970 at Washington on June 1970. And then it got amended in September 1979, further got more modified on February 1984 and October 2001. Then there is Convention on the Grant of European Patent, which got revised further. Then the Strasbourg Agreement concerning the International Patent Classification, which got signed on 24 March 1971. Then a major treaty, Budapest Treaty, on the international recognition of the deposit of microorganisms for the purpose of patent procedure. It got concluded in 1977. And a patent law treaty was adopted in Geneva, 2nd June 2000. So this is some treaty I have told how did the Patent Act got, what is the history behind, what are all the treaties and the conventions related to this patent. And in India, the law which regulate patent in India is the Patent Act 1970. Moving on to what exactly is a patent. Now that is a major question, that what is a patent. So a patent is a grant from the government which confers on the guarantee for a limited period of the time, the exclusive privilege of making, selling and using the invention for which a patent has been granted. Now what it means? It says, if I'll explain you in a line, that this word patent, it refers to a monopoly right over an invention. Now here, what becomes important is that what is invention? The definition of invention becomes important. Now the term invention, it is defined under section 21J of the Patent Act 1970. Now it says, the invention, it says that it is a new product process involving an inventive step and capable of industrial application. So first thing, it is clear that the word patent, it refers to monopoly right over an invention. Then coming on to the point that what is an invention. So invention is defined under 21J of the Act, which says that it is invention. It defines invention as a new product or process which involves any product or any process which involves an inventive step. First thing, and that inventive step has to be capable of industrial application. That is the second thing. So that is a definition. Okay, before moving on to the further elaborating on definition of invention, I would also like to tell you about the object of grant of patent. What is the object of granting a patent? Now the object of grant of patent, it is to encourage the research and development and innovation. 3 things. To encourage research, development and innovation. So in the case of the Supreme Court case of Vishwanath Prasad Radhesham versus Hindustan Metal Industries, The Supreme Court has enumerated the object of patent law, and it says so that the subject of patent law is to encourage the scientific research, the new technology, and industrial progress. These are the three things, summing up to that its main object is to encourage the research, development, and innovation. Then, moving on to the definition of invention. What does it all involves? It says, as said, involving any inventive step and industrial application. It should have some industrial application. Here, what does we mean by industrial application? Industrial application refers to capable, or it basically refers that any invention which is capable of being made or used in an industry. So any invention which is capable of being made or which can be used in an industry, that kind of invention is referred here as a industrial application. Now the very first thing, it is written new, novel. That the invention must be new. The second point is, moving on to, a novel invention is one which has not been disclosed in the prior art, where prior art means everything that has been published, presented, or otherwise disclosed to the public on the date of patent. So this means that it must not be known or used by others in this country, or patented or described in any printed publication anywhere. So basically that invention has to be new. It has to be a new invention. It has to be novel. That is what novel, original. It has to be a new invention. Then the third point, that it also must have an inventive step. First thing, it has to be a new invention, a novel invention, an original one. Then that invention must have an inventive step. Now what does it mean? It means that the work must be non-obvious, which means that must not be obvious to a person having ordinary skill in this in the art as it existed when the invention was made. So it must be a non-obvious work. As written, a feature of an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, and that makes the invention not obvious to a person skilled in the art. And then the fourth, it must be of industrial use. That is, the work must be useful. The work has to be useful. That is, an invention is capable of industrial application if it satisfies three conditions: that it can be made, can be used in at least one field of activity, and can be reproduced with the same characteristic as many times as necessary. Now what can be patented? The three things: the invention, any invention which is firstly new, which involves inventive step, and have the industrial application. So that is the whole thing. And also the last point is very important, that it should not fall under the section 3 and 4. Now what is section 3 and 4 of the Patent Act? It tells about what things cannot be patentable, what all things cannot be patentable. We'll talk about it later, but here this shows that patent eligible subject matters, anything novel, that is new, non-obvious, and useful, that can be patentable. Now non-patentable inventions. Now what are these non-patentable inventions? So here written: discovery, scientific theories, mathematical methods, scheme, rule, method. So there are many. If you see section 3 and 4, Any traditional knowledge, it cannot be patentable. Any any idea or discovery, it cannot be subject matter of patent application. Then inventions which are contrary to public order or morality, that is also not patentable. Then any mathematical method, any scheme or any rule, even anything, plants and animals in whole or in part, that are also not patentable. A method of agriculture or horticulture cannot be a subject matter of patent. So all of these things, if you see the section, you'll come to know about what all cannot be patentable. Here it is given. Section 3, inventions that are frivolous and contrary to the natural laws. Then second point goes against public morality. Then third point, inventions that are mere discovery of something that already exists in nature. It's a mere discovery, that it is nothing new. It was already there in the nature, it existed, but there's nothing new in it. There's no invention, it's just discovery. Invention and discovery both are the different things. Discovery is something which is already existing. Invention is that you invent. That it involves the inventive step. It is novel. These things, we also have to distinguish between discovery and invention. Then the list is long. If you read it, the non-patentable invention under section 4, this is important. Invention which are falling within section 21 of Atomic Energy Act 1962, that are not patentable. Now, that example, inventions relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and any more which are notified by the central government. So basically it says that any invention which are relating to atomic energy, that can also be not patentable. So that is the whole thing. Thank you. In the next in the next we'll be doing about infringement and remedies. And yeah, thank you.